Good evening, everybody. If I may, we're going to kick off. Hello, everyone. My name is Roland Mallinson. I'm at Taylor Wessing, but also on the Marques Executive Committee. So on behalf of Marques, I wanted to welcome you this evening. I'm not actually supposed to be here because I was supposed to be in an aeroplane, but my airline client that I was actually going to meet were the ones who actually cancelled my flight. So there's some irony in that, but I'm very pleased to be here this evening. I want to make for those of us, those of you who've been here before, you'll have heard me before make the same plug, but I'd like to make it every year. By the way, we haven't had this for a few years. In fact, we were the last event, I think, pre-lockdown, weren't we? So that was rather good. Day before, yes. So, but the plug I'd like to make is that Marques has an amicus curiae committee, and we put in submissions into cases on behalf of brand owners where we think there's a case that is very important and would have a bearing on other brand owners. So my plea is simply, if you have a case, for those of you who are practicing lawyers or brand owners themselves, we would be very interested to hear of your case if you feel that it's one of these ones that could be very important and would merit some support from a brand owner organisation like Marques. The reason I put in the plea is that actually, in order for us to take part in these cases, we really need to be involved very early, at the very early stage. So if you think it's a sort of case that might go on appeal to a higher court, either in the national jurisdiction or the European instances, then do please turn to us if you'd like our support. We'll consider the case and then decide if we're going to support you, and if we will, we'll put a pleading in and possibly attend the hearing as well and argue the case in support of your cause. And I hope, of course, the European judges would welcome the submission when they get them from us. I can't always say that has been the case in the past, but we'd certainly like it to be the case in the future. On that note, the only other point I was going to make about Marques is Marques is an organization where your firm, for example, or your company becomes the member. So everyone in your firm or everyone in your company could be essentially a member on the system, which then gives you access to all the know-how and all the publications that we put on. So it's not always appreciated that everyone in the organization could have that access. And for those who would like to have that access and your firm or your company is a member, please just let us know. We can then give you access to the website and everything else like that, because it's not always picked up. Thank you very much, Robin. I'll hand you over to him.
Right, the commercial break is over. But he won't mind. He has set the questions. I just get to read them out by and large. But you can all think of your own questions. These judges have all agreed to be your victims. I am really grateful to them, and so should you all be. So, I get to choose who answers first and so on. And the first question is quite simple. With the retained EU law bill making its way through Parliament, what part of existing UK EU-derived trademark law do the judges should consider should be at the top of the list for being reformed, revoked, or whatever? And what should be retained? Right. Richard, you're at the end of the table.
Well, thank you, Robin. Thank you for your invitation to come here this evening and to UCL generally. I feel I'm slightly passing myself off this evening because I'm not much of a trademark judge anymore because I get swamped with the patent work. But I find this a really difficult one to answer. I'm not ducking the question, but I really do, because one thing that's been borne in on me in discussions with the UKIPO and generally doing trademark work is the sheer scale of the work that's involved in working out what's being sunsetted and what isn't, not just across trademark law, but across the whole of retained EU law. And one of the bits of input for this talk was, I think it was from Al, was a very interesting list of what's up for sunsetting and what's not. And there's even discussion in government and what must be, I think, an interesting game of musical chairs with some hot potatoes being passed back and forth between different departments to talk about what could be sunsetted and what couldn't. So I actually gave this some thought, and I really struggled actually to come up with something separate and discrete that you could sunset without the knock-on consequence of, by the same logic, knocking out a huge amount of the EU law. And nearly everything that we've inherited has, of significance has been considered and adopted by our Court of Appeal. So my answer is, I think if you pick one thing, you'll unstitch the whole shooting match.
Right, that's a sort of British answer.
Yes. if I may say so, I call it the Newsnight answer, because it's rather like a minister going on Newsnight and saying that's a fascinating question, but I think the real issue is something else altogether. So you're right, it is a British answer.
Vesna, this is not really a question for you, but your question is a variant of it. What would you like to see changed in EU law? EU trademark law, you can leave the rest of it.
Yeah, that's just maybe if I can make some reference to the question. I'm not an expert in UK law, and I don't know.
You haven't got to get worried about it. But what would you like to see changed in EU law, EU trademark law?
You know, when I have a case in front of me, and when, for example, the trademark is registered for 20 classes, and in each class for 3 pages of goods and services, and we have to make a comparison, I'm lost. So, lost. So then we are trying to find out how to find and which products and services to compare. And then we made the subcategories, and I don't believe that there is a company which can register for 25 classes and then in each class 27 products and services. Maybe I would change that. This is not about substantive law. It is about substantive law. It's a technical question more than about
Al, what about the Patent Office? Supposing you were given charge of all changes you could be made to trademark law.
I'm going to do an even more Newsnighty answer, which is I couldn't possibly comment. We have identified 82 pieces of legislation that are affected, and that doesn't include case law that's not been adopted. So on the what would you keep, I've always said that if Merrick ever goes, I'll retire. So I may have to think about looking at my retirement numbers if we end up losing Merrick on the basis of the long specs we were talking about earlier, because that's the only thing that helps, essentially. But yes, in terms of what's going to sunset, I think that's still up for debate. And I agree with Richard, I think it would be hard to pick something that didn't affect lots of other things.
Yeah. Sven, you get the straightforward chance of amending the European Trademark Directive and
this is like presenting a wish list. This is great, but unfortunately it goes to the UK, not to the EU legislator. But anyway, maybe they hear me out.
I'll take some.
No, but I mean, to start with, I think it is important. I mean, of course you will bring in your ideas, and this is needed, but nevertheless, I think it's very important, at least from my personal view, that you don't change too much simply because it's not good for the business. I mean, all these business which are used to the EU system, which you belong to quite recently, I think it will be very difficult. It is not the EU, it's international business. If they now find a legal environment in the EU for all these 27 member states and then another one in the UK. So my suggestion would be to change as little as possible. However, I have, if I can, a couple of ideas. I mean, to start with, you have brought some very good cases to the Court of Justice. I mean, the IP translator, Skykick, so I fully agree with Vesna that, of course, it is not a good solution to have brands, trademarks registered for 20 classes. I mean, we even have cases with 45 classes, and this is not an exception.
Well, why did they leave out the other one? 45, but there were 46 classes. Why did they not have the other one?
That's a good question. So this is not a good solution. Yeah. So we need to find, but what do we want? The intention to use system like in the USA? I don't know. Or you said before, when you ask for your renewal, then you need to actually specify and can only renew those goods and services which you have for which you have used the trademark. But I think it's taken too long, it's 10 years. And also the proof of use period the grace period is 5 years. So I think we need to drastically reduce, or I would suggest actually to you to reduce this 5 years to maximum 3 years. Because otherwise you get a huge protection. I've just given this example to make it clearer. in our practice, the EUIPO, you can register the trademark for software alone, which I think is totally wrong, but this is maybe another discussion. But then you have 5 years where you can go after each other similar trademark which has any type of software, more specified software. And in my view, this is far too broad, this protection. So what I would have loved to see in the Skykick case, that actually the Court of Justice confirms that there is a possibility to file an invalidity action against the trademark, saying that either it was too broad and imprecise the terms, or there are just too many and you will not use them. So I think we need to find a way out here, and it's not difficult, but maybe you find it.
Well, my own suggestion is there should be a crime of filing a trademark specification which is too large. Triable at the Old Bailey.
Strict liability, obviously.
Sorry, if you allow me, and I think what we also need is the possibility of expungement, as you have in the USA. So we need, actually the offices should have the possibility to actually ex officio initiate revocation procedures, and it's clear that you don't use the trademark, because now our hands are tied. If you don't file a proof of use request or a revocation action, we can't do anything. So actually the offices, in my view, should also get the possibility like in the USA.
That's a very good idea. Just when you huge specification, when they come along and say, please renew, you say, well, proof use it.
Exactly.
And then you wouldn't have to do it in every case. Little ones wouldn't bother. Should trademark law have an explicit parody defense? And you will know that the United States, Jack Daniels is fighting bad spaniels at the end of the month. Who would like to answer that? Sven, do you want to start there? Your Swedes are not supposed to have a sense of humour, but this is for you.
So I have to prove the contrary. Anyway,
You have, yes. You're sure you're Swedish?
In the EU law, I mean, we discussed it, Vesna, no? In the law there's nothing. As it stands now, the EUTM directive and, of course, the regulation. I mean, they will actually add it now in the design reform. That's the first time that they will add this parody defense. So it will be in designs. Maybe it will come in the future also in trademark. Makes sense. I mean, we have a couple of case law, and maybe Vesna can also go into it a little bit more in detail. And I remember there was one case which was actually the Screw You in the Equo Puta case, where actually that was an argument. And by the way, for us, the parody always is under the freedom of speech. For us in European case law, it's always it will be examined under the issue of freedom of speech. And then they constantly said the courts that there's no room to examine or to consider that in the trademark cases. Yeah. But there was also recently the Fuck You Goethe case from the Court of Justice, where they actually said, okay, we need to also be reminded of freedom of speech. But they didn't really answer how in practice we should do it. So what my point is, it's not in the law, it is mentioned in the case law, but we have divergent case law, and we need to further develop it. Yeah, but I think the best way would probably just to introduce this parody defense by a legislative reform.
Vesna, what do you think? Do you think that should be a change in EU law?
As Sven said, we don't have it.
You haven't got it.
In all the cases, trademark I dealt with, it didn't come to our attention that the parody can be some element we can take into account.
That's what I said, the really trademark lawyers haven't got a sense of humour.
No.
Richard, do you think we should do something?
Well, I'd be interested. I mean, I only saw the Bad Spaniels bottle when we were just out here looking on the internet as we were getting ready. But I must say my initial reaction is that could, if the evidence was right, damage the trademark function for Jack Daniels. And so what would the parody defence say? Would it say it's all right to be a parody even if you damage the trademark function? That's quite a strong thing to say. And if you don't damage the trademark function, I question whether it might not be possible to bring a defence within Article 12, even if it's not explicitly called out as a head of defence in itself.
Will the European Convention of Human Rights have anything to say about this?
Well, good question, but why would it not? I think I'd answer your question with a question if that's not rude. Why do you say, well, that's all right, even though you damage the trademark function? Do it in a way that doesn't damage the trademark function, I think would be my response to that.
Yeah.
I am no scholar of the whichever First Amendment, is it, to the Constitution?
Yes.
I'm right about that.
Yeah.
But I rather get the impression that does say bad luck if it damages your trademark function, or it might do.
Well, we'll see what they do.
But that's because of the way that policy has drawn the balance in the United States, and it needn't be the same balance in Europe, I would say.
I mean, you can easily get to the US website, US Supreme Court website. So if you want to go and find it, I think it's on the 22nd of March. And they'll, of course, be arguing it in our evening, so it'll be evening entertainment, or thereabouts. 6 hours. There have been quite a few cases, actually, of spoof trademarks and spoof designs and so on, all of which, I think, quite a few German ones, where the defendant won. The problem with, I think, bad Spanish is probably it's also rather offensive. I mean, the text on the thing is not very attractive.
Well, I just thought it was very, very similar at first glance, actually.
Yeah,
I think out of the corner of your eye, it looks like a Jack Daniels bottle.
By the way, have you all got who all the judges actually are? I suddenly realise you've got it all. Good. Right. Should there be a limit on the length of written submissions in your courts? Would you like a limit on the length of written submissions? Vesna?
We had, we have a very long submissions.
Would you like a limit?
Repetitive submissions, not maybe to the point. Yeah.
So you would like a limit, 20 pages?
We have a limit at the court. We have a limit about 50 pages. And in trademark cases, it's the same for the state aid cases, anti-dumping cases and trademark cases. In trademark cases, it's about 25, 30, depending on the number of classes of products and services. But we are third instance. If we have, for example, Conciliation Division, then it's a Board of Appeal, and then it's us. So it's already, I think that we have to think about really some specific questions. And then the problem also, which I see, is when we have to have an audience in trademark cases. We have a rule in our rules of procedure that we have audience only if the parties ask for the audience. And we have also in the rules of the procedure description that the parties have to motivate the request for the audience. And it's never motivated. So at the hearing we hear what is there in submissions, and submissions are very long, and I don't see the purpose of it sometimes. So, but I was also between the minority saying that maybe we don't have to have a hearing if everything is clear from the written submissions, because it costs the money for the parties. And the experience I have in 10 years of being at the court is that sometimes I'm asking why we have a hearing. Then the good thing we can have we can adopt the order saying that the case is manifestly unfounded. That's helped. We don't have to have a hearing. But the majority of the judges, they want to have a hearing. They say, the parties say, we want a hearing, we have to have a hearing. So it's like a right to have a day at the court. But the submissions are very long, they are repetitive, and I would like to see that we have audience only in the cases which really merits the hearings.
Sven?
Well, before I start answering the question, I will give you an example. And what I really ask you all is, if you make the submission you ever do, never use Google Translate or any kind of automatic translation to send it in a different language, because you know that we deal with all the 23 official EU languages. And you can't imagine sometimes long observations, and you don't get anything because they have used Google Translator. I will show you an example. German, once a colleague came to see me and said, look, Sven, why are they always talking in this opposition case about German roundabouts? And I said, I have no clue. And then I was thinking, wait, German, and then I said, this is the German part. He said, yeah. And then I thought, roundabout in German has two meanings. One is a relevant consumer, and the same word also means roundabout. But so you see, I mean, this poor colleague, he said, why are they talking about the German roundabout? I said, because in German it's also relevant consumers. And then he goes, I can take a decision now. But seriously speaking now, I agree with Vesna. It is sometimes shocking to see how many pages we get. There's no content. So what is important, and for me the issue is not the length of observations, but it's the quality. You need to make your case and you need to argue the case. And the important thing is, don't tell me that the signs coincide in 3 letters and whatever. I mean, this is easy. But if you have goods which are not clothing and footwear, which I can also compare, and there's tons of case law, but when you come to the tricky cases, you need to tell us, and you need to even submit evidence why these goods and services are similar or dissimilar or whatever. This is interesting. It makes your case. I give you one short example where it was decisive in the case on similarity of non-alcoholic beverages and alcoholic beverages, because the long-standing case law said it's dissimilar. But then actually the opponent filed a new case, and they actually proved by solid evidence that there was a shift in market reality. So they proved there was a shift in market reality, that nowadays, at least in Spain, wine producers produce alcohol wine and also the non-alcoholic wine. So this is a very important factor which you need to argue. Also in the 8.5 cases, I mean, to be very honest, most of the 8.5 cases, we could just dismiss them because nobody's really explaining what is here the unfair advantage, and even less any evidence. So for me, it's not the length, it's the quality of the submissions.
I have often wondered whether full stops are very expensive in Germany.
Oh, yes, they are.
And my daughter-in-law is a German lawyer and also an English lawyer, and she sometimes has to translate things from American clients and so on. She says German judgments can't be translated.
Yeah, but Italian either. True.
Does the office have any views about cutting down written submissions?
Well, I do, even if they don't. I would say, as well as cutting them down, because they are often, as everyone has already said, useless by and large, take the submissions out of the witness statements, because they do not belong in there, and put them in the submissions, and actually, as you said, Sven, wrap up the case. That's the point. So, I don't want to see my decisions, that lots of people will go and find your decision, give you loads of bits of your previous decisions back at you in submissions, wrapped up with repeats of the witness statements and the pleadings, and it's absolutely useless. And it's sort of 15 pages I've had to read completely unnecessarily. So skeleton is a clue to your arguments. They should be thin and not well fed. The clue is in the name. And I would say the same for submissions. This is my chance to moan now, so I'm really enjoying this. But yeah, witness statements with submissions in as well are just as irritating as long submissions, I would say, where you've got witnesses giving you case law that they clearly don't know. They're a witness who works for X company, and you read it and think, well, they put the A to K list of 52B in there, which they obviously don't know. So yeah, I would say just think about what submissions are for and focus on that rather than giving us lots of unnecessary information. And if it's really vexatious, you will be penalised in costs for it as well, because the other side could raise that as a waste of time, and I'd listen. It was ridiculous.
Well, you can do that, but other courts can't do that. And anyway, you've got to realise that these lawyers are being paid so much that the cost, one way or the other, don't make much difference. It's fair.
It just makes you feel better, Sir Robin.
Just add one thing on these submissions. You usually have to submit a lot of evidence. And actually we have now aligned with the General Court, because the General Court, he has already said you have to submit an index and you have to clearly structure the evidence. I see everybody nodding, but you can't imagine sometimes we get boxes of 10,000 pages without any structure, and then the lawyers just say, you find the evidence in the boxes. So is it my job to go through 10,000 pages and to find the relevant evidence to say the trademark has been used or not? And by the way, an inter partes proceeding, you will get a copy. Yeah, so you will get a copy, and the lawyer is also not nice to go through 10,000 pages without any structure. So that's very important. Actually, now we start to dismiss evidence which is submitted, as the General Court has done for many years already, when it's not structured. So you need to have an index, and even it is important that in your observations you say, okay, this fact, for example, the extent of proof, you find the evidence in Annex 1, page whatever, and then I can go to the annex and I will find it.
All right, some lessons from practitioners there. I was involved in teaching a class last week about the defences in trademark actions. And I couldn't think of a single case which turned on any of the defences. Now, I may be wrong, but do they serve any purpose? Or is the whole of the defences really subsumed in things which are non-infringements anyway? Can you think of any cases where the defendant won because of a defence? Yes?
Yes, I know.
You know some. How many in the audience know some? I couldn't think of anything in my entire career.
I can tell you a near miss. I had a case when I was at the bar, which I think was in front of you possibly, which was an own name defence, and as it happened, the company it was a corporate defendant, so the corporate defendant lost, but it was one of the young members of the Asprey family who split off.
Oh yes, I did do that one.
And he lost, and he also lost on the facts, but he could have won if the facts had been not so very different actually. So I think you can, without too much difficulty, think of a narrow category of cases where the own name defence is what could make a difference for individuals.
The trouble is I'm not sure you can, because if the trademark, if it's causing deception or confusion, then it's not in accordance with honest practices. So you've got to stop. So I reckon, anyway, they certainly aren't there much, are they?
True.
My students haven't found any yet.
But what, if you allow me, I mean,
Yeah.
the defense is because I actually see a lot of cases where I question myself, why on earth have they not? I mean, the most easy thing which comes as a defense, I mean, we have a lot of type of things, the proof of use. I mean, you can't imagine how many cases we see that the lawyers, they don't raise the proof of use. And also, I mean, in our system, we have a fixed deadline when you can submit or request the proof of use. Even if you've missed the deadline, or if the earlier trademark is still in the 5-year grace period, but you actually see that in a couple of months they will be out of these 5 years, don't worry, file a revocation action. I mean, hardly anyone does it. You see, actually, okay, it's true they couldn't ask for proof of use, but they could have waited 2-3 months, even asked for extension of deadline. Nobody knows why you asked for it, and then you file, boom, you file a revocation action. Yeah, acquisitions on invalidity cases, you can't file an identical invalidity action on the same earlier rights. So there are a lot of defense possibilities which are simply not used by many because they are unknown. And also res judicata. I mean, I'm surprised that sometimes nobody comes with res judicata, although this is a clear res judicata case, right?
It seems to be a universal rule of nature that when it comes to proof of trademark use, people don't do the job well.
I agree.
Sven.
There's just been a big case, hasn't there? Some very well-known mark.
Big Mac.
Big Mac, that's right.
Yeah, the big case, Big Mac.
I wonder if the lawyers are still acting for them. Never mind.
Yeah, so then it comes the question, is the use of Big Mac for Hamburg a well-known fact? I don't know.
Well, it's one of the questions. Should a judge be able to take notice of judicial notice? That means, in English law, that means the judge can say, yes, that's such a well-known fact that I can take it as a fact, and it hasn't got to be proved. Should a court be able to take judicial notice of a very well-known mark? Do you agree? Yes or no? Because that would have solved Big Mac's problem.
You asking me?
Yeah.
Oh. I've tried it a couple of times. Unfortunately, I was overruled in my board. My colleague didn't agree with me. But I think definitely it's something to develop, and it would be really interesting to see what the General Court is saying. I mean, we are using a lot of well-known facts. You have the Messi case, where they messed it up, in my opinion. But okay, that's a different story. But I mean, I would say yes, because, for example, Google, for internet search, I mean, why on earth do they need to prove it? Big Mac for hamburgers. The problem is more, where do you draw the line? Yeah, because usually with one product or one service, you probably don't be able to get to against the whole specification of the contested mark. That's a bit the problem. Where do you draw the line? But why don't we think of, that's another suggestion to you, why don't we think of a register of famous trademarks or even use trademarks? I think it's not a bad idea. There are many jurisdictions they have it. Yeah? But why? But because I see the point, because I know from context we have with the user, with companies, big companies, they actually always say, okay, a monopoly is a good example. I mean, you hopefully know my monopoly case. But not doesn't matter. I mean, I understand monopoly because they say you can't imagine how many oppositions we are running every year, not only in EUIPO, not even in Europe, worldwide. And of course, it's very expensive to always show the use, the reputation. Yeah, I agree with it. I think with the register might be a solution. I mean, refiling, in my view, is definitely not a solution. And the door was closed by us, confirmed by the General Court. But it is an issue. It is an issue. But the problem for me is a well-known fact of reputation, but for which goods and services? That's a bit the problem.
Does the British office take judicial notice
I
of very
have
well-known
done.
trademarks?
Yeah, I have done in cases recently, actually in Spotify, but I can't remember if that's past its appeal period yet. So watch this space; I might get overturned. But at the moment, as it stands, yes. But I mean, the other side didn't particularly contest the music streaming reputation anyway. But I did take it on judicial notice. We have actually, on company names cases, issued a statement about a particular company to say that goodwill no longer needs to be proved for X, Y, and Z, because we had so many cases and ridiculous evidence burdens, because there aren't the same limits that there are in trademarks on evidence, because we limit it to 300 pages around.
Okay.
Because we used to get trunks, and now we don't.
Okay.
And if people want to file more, they can come and argue.
Yeah. Okay.
And depending on who they get, they might be lucky, they might not. But yes, I think it is something we should be able to do, but in limited circumstances, I would say.
This is not so much for the General Court because it's an appeal court. But if a case came up where somebody said, well, they hadn't proved this famous mark was famous.
I think that we cannot take it as a fait notoire.
No, I think that.
And if the opposition party contests and say, no, you don't have a renommee, then we have to go from scratches. And even in the recent series of Puma case, everybody knows what Puma case is. I read in one file dossier that 95% of Germans understand what's behind the Puma trademark. But if the other party comes and contests, we have to go all over. And it's very, very expensive. And it's a lot of proof has to come. I remember another case which doesn't have to do anything with renommee, but with the proof for the distinctive character which is acquired by use. You all know this KitKat chocolate bar, and that was the case which I really enjoyed very much. The final solution was not what I envisaged, but the court confirmed our decision. So everybody knows about KitKat, how it looks like. And the Nestlé wanted to register only the chocolate bar. Mm. And then the Cadbury came and said, no, you cannot do that because it's a form of the product. You cannot register it, and we can have it on the market, but it's always wrapped in this red plastic. And I remember that KitKat Nestlé came with so many proofs, and it's very expensive. They came and said, you have a proof that we have acquired distinctive character in 90% of the territory of European Union. And this proof covers, 95% of the population of the European Union. And no, the case law says no. You have to prove in every member state. So I was said it's it's nonsense, because wherever you go, I came to the airport, you have Kit Kat everywhere. I went to the store, I went to the hotel, everybody knows what it is. No, we have to prove it for every member state. For example, in Luxembourg, where there is, I don't know how many, 500,000 people are living. So for the moment, we can't do that. If the other party contests the reputation, then but if you are so big company, then I think it's not that much difficult to come with a proof. You have to come with turnover, with market share, and big companies, they already have everything.
I agree.
Yeah.
I think they say it's much more difficult than it actually is. They're very famous.
Yeah.
It really is very
Yeah.
easy to do.
I think that it's not difficult for them, but I do agree with Sven. Maybe we should introduce something. We know what Google is. We know what Facebook is. We know what, I don't know.
Well, I mean,
Yeah.
there's a question here about how reliable it is to use internet searches when you don't quite know who's been putting it up and whether it's true or not. How much do you reckon you can rely on it? Just results of things from internet searches and nothing else?
Yeah. I would not know.
Well, I think the answer nobody knows. Incidentally, I went to a trademark conference in Holland and distributed to all the attendees of this conference, as well, a small one, was something that looked like Kit Kat, but it came in a different colour, and I think was made in either in Denmark and had been for many years, or Holland, I can't remember which. We were given it for coffee, it was a sort of joke.
But Robert, if I may, I mean, also, I mean, don't forget that you have actually the possibility, if you have these cases where you defend and refute a trademark, that you can refer to other previous judgments and the evidence submitted therein. This is very important. I mean, theoretically, of course, we have, as Vesna said, you have to prove it in every case, but of course you can make reference, right? So you don't have to necessarily submit all the evidence in all the cases. It depends a little bit. You have to also be careful if the case is 10 years old. Of course, if they said there was reputation 10 years ago, not necessarily still now, 10 years later, but if it's just a couple of months or years, then we actually have to consider it. This was also one of the Puma cases. And also for the acquired distinctiveness cases, the Kit Kat case was really a landmark judgment, and I actually fully agree with it, because it's trying to find a balance between, yes, you have to show acquired distinctiveness in all EU member states where the trademark is not distinctive, but you can use the extrapolation. So also don't forget, in acquired distinctiveness cases, this possibility of extrapolation. But if you do so, because I have not seen, since when is this Kit Kat case taken? Years ago, I have not seen one single case, and we get 3,000 a year in our boards, where the parties really argue with the extrapolation. So you need to first say, okay, which are the countries we can group together? Classic example, Germany, Austria, Benelux, these are, or Spain and Portugal, these are the classical examples. But you can't just say it. You need to prove it, or need to argue why these are, let's say, common markets, and then you can draw a conclusion if there's reputational use from one market to the other market. Yeah, that's important. So again, we're coming back to the quality of submissions. You need to really argue it. I haven't seen any case yet on this extrapolation, although I think it's a very good idea. The Court of Justice in the General Court came up.
Some of the questions relate to too many points being taken by an opponent against a trademark, or too many citations of earlier trademarks. Do you think it would be useful to have a rule that you shouldn't be allowed to run more than, say, 5 points?
We already limit numbers of earlier marks that can be relied on. So I think it's 6 in a standard case and 3 in a fast track case as a right. And then if you want more, you can, if you're running a family of marks argument, or you've got lots of registrations for different bits of goods and services, then obviously you can make the case to rely on more. But generally, 3 does it, I would say.
Actually, 1 is a good.
1 normally does it, yeah. 2 at a push.
I mean, the EU system doesn't have any system for judicial cutting down.
No, we don't have it.
Do you think you should? Do you think you should?
To be honest, I don't know, Vesna, but I think it's very difficult, because don't forget, sometimes you have different. it's very difficult because I remember a lot of cases where, for example, they invoke a lot of trademarks. OD said there's likely of confusion with trademark A, let's say, yeah, and then they filed an appeal, and then we at the board actually said there's no likelihood of confusion with trademark A, it's actually with B, for the reason because they're more similar or they cover different goods and services, and therefore, I as a decision taker would be extremely happy because it makes my life much easier, but I don't know if the users of the system would like it because it can make a difference. Yeah, there might be cases where it's clear cut, and actually with this mark you will kill it. Yeah, to say it that way. But there are a lot of cases where it depends, and also the case goes then on to the court, and the court might agree or disagree with the analysis taken. So I think it's actually good to invoke all the earlier rights. And as you said, Robin, in our system you have to bring all the earlier rights. It's very important.
This happens in not just trademarks.
Yeah.
An English patent under attack, the skilled practitioners will hardly ever run more than a few points. In the opposition system of the EPO, they may have 60 pieces of
Yeah, of course, even more. No.
There is a old story about the Irish Council. They've got 17 points, my lord. 17. Which is your best? Oh, that's for your lordship to decide. Now, one sort of practical thing. Through COVID, you had to have hearings virtually all the time. Now you've moved back. The EPO hasn't, for opposition. The President has decreed its basic rule is going to be online. Tell us about your experiences online versus in person. Richard, you haven't said anything for a bit, and you had to do quite a lot of things online.
Well, I was non-stop online, round the clock every day for about 9 months when I started as a judge. I was just in the last couple of days, there have been a couple of EPO decisions saying that it will now be the standard, and that they have rejected the decision reached by the enlarged board, which Rich Long was on, that it remains the gold standard, and they say that now we're out of the pandemic, it will be online across the board.
Only at the opposition division.
Yes, that's right.
The TBAs are carrying on in person.
Right, but it's still a strong thing, that I think, and in fact I found as a practitioner in the EPO that being there in person was terribly important in opposition proceedings. But they will make their own decision about that. I didn't find it difficult to assess witnesses online. I think it's a fallacy that you need to be able to see the sweat dripping down their forehead to tell if they're telling the truth or not. I don't think those are the best tools for telling whether people are telling the truth or not. The things I found difficult were the sheer exhaustion of doing long hearings day after day on Zoom. Very, very tiring when you're the judge. You can't afford to let your attention drop for a moment when the audience are effectively 18 inches from your nose. And I think that in certain categories of hearings it obstructs settlement because the parties can't talk in the corridor. I've noticed that as a major effect. So all in all, I welcome doing things in person again. I'm doing the urgent applications this week. These are the hearings that take place on very short notice. Each day a judge takes control of those. Those work much better in person, partly because of the settlement effect. And I think also non-verbal communication doesn't work on Zoom in subtle ways that are very important in court. It's very hard to pay attention to everybody in court. If you're on Zoom, your eyes get drawn to whoever's talking. And quite often in court, there are subtle hints that somebody wants to say something, to take a prosaic example, and you don't notice that. And even talking across each other with the advocate, which happens much more on Zoom than it does in person, is a hindrance to communication. So I think it has its place. It's terribly unfair if somebody has to travel 3 hours for a 10-minute hearing, and we should be sensitive to that. But where you're doing a final hearing where the actual result of something important is an issue, I think it's a less good quality of justice to do hearings by Zoom, whatever it might be.
Vesna, how did you find it on Zoom? Or maybe you didn't use Zoom, maybe you used Teams.
I'm using Zoom in its generic sense, Robin.
Yeah, we didn't do that before the COVID. And during the COVID, the court established a special connection. So the office insisted to do it by video conference. I did find it very satisfactory. We didn't have any problems. I think I was the first judge having a hearing by video conference. I did it with one party present. I did it with both parties absent. And yes, it's not the same. It's not this personal contact. I don't wear the robe and all this stuff. But I think it's quite... I'm a really practical person, and I find it very practical because coming to Luxembourg is not easy.
No.
And it's expensive. And to come to Luxembourg to have 1 hour of hearing, because as I said before, very few hearings were really, really substantially important for us. So to come to repeat what is in the file, then we ask few questions. The representatives, they are repeating what's in the file. And after the COVID, after this tragedy ended, the question was whether we will keep video conferences for the hearings. We had a long debate at the plenary session, and I was proposing, for example, we can have a video conference if both parties agree, not if they do not agree. If both parties agree, if they find it fair enough and reasonably acceptable, that we can have a video conference. But majority was against. We have this special provision in the rules of procedure saying you can have a video conference, but it's almost in case of war or, the force majeure cases, something like that. So, yes, it is true that the personal contact and discussion is very important, but not in every case.
So we operate a cut-off now of, roughly speaking, half an hour or an hour.
Yeah.
Then we readily do it with Zoom.
Yeah.
But a longer hearing or the final decision in a case, then we aim to have an in-person hearing. And
may I ask you a
Yeah.
question? Because in the General Court, if I'm not mistaken, Vesna, you have an online oral hearing, but the public can actually not connect, so they would
Yeah.
need to sit in a
Yeah.
courtroom.
Yeah.
Is it because we do we do very little oral hearing, but for example, the last one, the Iceland, what we did, so everybody, the parties were in our courtroom, and then some parties were connected online, and then the interested, so that's the participants, the audience, they could connect by a specific link. Is that the same what you do or is it excluded?
So it's quite a complicated question, that, because it's tied up with preventing people from recording the hearings or photographing them, which is not allowed in our practice. One or two courts in the Court of Appeal have a standing live stream on YouTube. Court 71 and Court 763, I think. But for important cases, they have a general live stream on YouTube. We have a practice where we have to individually permit people to have a link.
Yeah.
And my own practice is that I permit it fairly freely if I know who they are, or occasionally they say, well, I'm a journalist and I don't really want to tell you any more than that. And then I use my judgment. But it's been quite rare that I've said no, very rare. So in general, I think you're right, because we have an important adherence to open justice, and if you have a link that nobody can attend, then that's not a good thing. In the very first case I did in the pandemic, we didn't really have rules at that stage, and there was just a live stream, and my children were watching it, and my mum as well, which I thought was quite a good thing. But we hadn't identified the potential problems with it then, so we didn't have the formalities around it to.
But I think it's a big issue, because here, as you said, I mean, access to justice is not only access for the parties, it's access for everybody, because everybody can go to the courtroom, just sit there and listen to you, right?
Yeah,
so
it is.
For me, the online hearing issue, that's a tricky one.
Yeah, but there is a real concern about the potential misuse of a video, and especially if you allow somebody who wants to attend the proceedings from abroad, you have no easy control over them if they do misuse it. So it's a real difficult balancing act actually.
But we actually ask, if you want to listen, you need to register. So we actually have the name, IP address, email address, everything. So that we try to balance it out, because you're absolutely right that there might be a misuse, of course. But we tried a little bit with registration, but I don't know if it's a good solution.
Yeah, we publish the hearing list, and then if people want to attend,
They
contact the hearings clerks, who will then send them the.
But do they get it immediately, or you assess it like
Well, it's open to the public, so
Okay.
we can't. If it was in the courtroom, we'd let them come in. So
Yeah, the electronic world has got all sorts of extra implications for security. The case management system for the UPC, that's one of the reasons the whole launch of the court has been delayed, because that system has got to be so secure. Anyway, I have no other take on it, but I know that's why it's gone back 3 months. Iceland, this is a question for the audience, really. If you saw Iceland on a freezer, would you say, that comes from the land of the geezers and fish? Or would you say, this is just some chap selling a freezer under the rather silly name Iceland as a sort of promotion? How many think would wonder even that it came from the manufacturing source of Iceland? Anybody?
Well, it did originally.
Did it?
Historically, that's why it's unusual, because you wouldn't think it did.
How can anybody make the freezers in Iceland?
They actually do.
Factories.
They actually do.
The government of Iceland owned the company that made the freezer.
Oh, I see. Well, they just cut it out and stick it in the iron thing and make machines work. But I mean, really, that case was wrong, wasn't it? Perhaps I won't ask the
But Robin, the question for me is, look, I mean, of course, you have the one possibility that you already have, for example, let's take the country case, and then you know that they're even famous, but they don't need to be, the country doesn't need to have reputation for the production of this product or for the rendering of the service. That's very important, because it's always misunderstood. The Chiemsee case didn't say it. You need, if it's known, okay, then it's the easy one. But the Chiemsee also said, if it's reasonable to expect in the future that this product or service will be offered, or the product will be produced, or the service rendered by the country. And to be honest, a freezer that this will be produced in Iceland is more than likely. I mean, nowadays all the economies try to make business and money, and they will go wherever they find a way to make business. So I don't see that excluded. There might be some very specific goods which is clear, which they could never be produced in a specific country. These are maybe excluded, but for the rest, it's always reasonable to expect, because people want to make business.
There's an old case an English judge gave an example of North Pole for bananas.
For example, this is a good one. I like it. This one, there I can agree, but for the rest, I think. Anyway, the case is now before the general court, so they will take
better
this down.
answer it. It may not be your.
But should we really allow geographical names as trademarks? I mean, I'm asking you, what do you think? My personal view as a lawyer, not as a chairperson of the second board of appeal, as a lawyer, I mean, I have really difficulties why on earth do you need to have a trademark, a geographical name as a trademark? I mean, everybody will link it, because it's just the source where you have your company, where you render the service, where you produce the products. To be honest, I would be, if I could personally, I would be much stricter than we were in the Iceland case.
Robin, can I ask a question or make a comment on that?
Yeah, okay.
Thanks.
Your Marx, you organised, you invented this topic.
I mean, so there will be some country names or place names that might be valid because there's no potential connection. And then actually coming back to your earlier question about the defences, one could reasonably say, well, just rely on those exceptions where you let those rare geographic names operate as a brand. If someone then wants to then use it in a totally fair, honest, descriptive way, by reference to freezers actually made in Iceland, the likelihood of that being an infringement, if you have a decent, well-defined defence, that should be fine. That addresses that problem, doesn't it?
Yeah, if they were using it as the name of the country, and clearly it's the name of the country.
Yeah, they want to say, I make my freezers in Iceland. Well, that's not going to be an infringement then, is it?
No.
Might be. But I mean, I was talking about the registration. I mean, I see your point on infringement. I mean, this is true. There are two different layers here. No, this is absolutely true. But for the registration, I mean, you can use it. As you said, you can still use it. But to get it, because I think we always forget that you get a monopoly. You get a monopoly for which is not. I mean, it's if you pay the renewal fee, it will be there for 500 years, even more. We will be all dead.
But
We will be all replaced.
the point is that the problem is that actually virtually anything can be made at virtually anywhere. So in which case,
Yes, a little bit.
there would be no geographic name of any that could ever operate as a brand under your.
Yeah. But again, this is not very important. This is not office practice. This is not case law of the boards of appeal. Neither not of the general court. It's my personal view because I don't understand why do you need. If you include it, that's a different thing. You have a brand, you combine it with a geographical name. But why on earth do you need Iceland or the United? I mean, imagine a United Kingdom is a trademark for. I don't know what cars. Why on earth you would never? I mean, I think I don't know. Maybe it's just me. But I think we should not accept geographical names, and I'm not talking only about country names, city names, rivers. I would even go so far with streets. I mean, if you tell me a trademark streets for shoes, it's obvious that, or it might be perceived at least by the relevant consumer, that the shoes are sold in that street. But it's
Does everybody agree with that?
no.
You want an absolute rule, street names upwards, no registration. It's almost like you're.
I know. I'm always alone with this, as I know.
You sound
But I have no problem.
You sound as though you're on the way back to the first British Trademarks Act, where there were only word marks and they had to be invented words.
Excellent. I like it. Because these are, and also look, don't forget, I mean, this is also true. Sometimes people try to get these super weak trademarks. I think we come to another question on weak marks. But I mean, can never be strong marks. I mean, the strong marks are these marks, invented marks. These are the strong marks. And there you can build up a reputation. And there you have really a strong scope for protection. But not with geographical names or with weak elements, because what can you do with it? The scope of protection is very limited, if the judges understand it.
Do you think we're a bit soft on weak marks in getting them on the register? They ought to be seen as becoming fat stronger.
I say only yes. And this is a big problem. It fires back in all the opposition proceedings. I mean, I guess you have the same. I mean,
do you think the same thing?
Off the record, yes.
Oh, nobody hears this in the court. Do you think that the general court is being a bit soft on weak trademarks, soft trademarks?
It's better?
Being a bit soft. You ought to be a bit tougher and say, well, this is not really a trademark and you haven't proved it properly.
Yeah, we are soft.
No, but I have to say, Vesna, I mean, to be honest, and again, I think that the general court has made an enormous change and effort in finding a harmonized approach of the case law. So actually now the general court, I mean, we at the board, we always, I mean, not always, there is divergent case law, but for the last years, we have tried to shape the case law in a sense that if a trademark, or let's say if two trademarks coincide in a weak element, there is no likelihood of confusion. And there was some different judgment from the general court. But now I have to say, in the last 2 years, you fully align with us. You can't base your case on a weak element. There's simply no likelihood of confusion. Unless, this is important, the other elements, which are totally distinctive, are similar. And then, of course, you have a likelihood of confusion. No, this is crystal clear. But mostly, I mean, I remember the Natura Roma, Natura Nova case, but the endings were also very different. And then, of course, you have no likelihood of confusion. But I think, because this part, we should be also stricter a little bit on absolute grounds. Yeah, in my view.
Yeah, just in order to deal with this case law which goes in all directions. We are 54 judges, and 3 years ago we introduced something like a specialization. We are not, I'm a general, just deal with very many cases. Trademarks are 1/3 of my portfolio. Now we have decided that because of this incoherence in a case law, we have introduced specialization. 6 chambers out of 10 have the trademark cases and 4 civil service cases. So there is one, how would I say it, way to deal with the disparities in the case law, and I think this is the result.
Exactly.
Yeah.
It is fantastic,
Yeah.
Vesna.
Yeah.
Fantastic.
Which do you prefer?
Sorry.
Service cases or trademarks cases?
May I be honest? In 2019, when we have introduced this specialization, I was the president of one chamber, and the president of tribunal asked, general court asked us, tell me what is your preference. And I spoke with I don't work alone because I would not be able to do anything by myself. I have a team of young people working with me, and we are all judges, so I'm not the. And I said, guys, what we will do? And they told me, the trademarks, we can have a bigger statistics. But sometimes in civil service cases, we can find some questions which are legal questions which are complex. I said, okay, then. I wrote to the president, we will opt for civil service cases. And then day after he came and he said, we can't do it because everybody wants to work on civil service cases. And I said, I'm expert for none of these areas, so I can do trademarks. And now, 3 years after, everybody wants to do trademarks.
Do they?
Yeah.
But I think Vesna, I agree with you, but again, I think you have really harmonized a lot the case law, but there's one thing which you should never forget is because of case, if you go to a country like UK or another national state, it's relatively easy to examine the case because you only check one language. Never forget when you read our cases, those from us and from the General Court, that we have to examine the case on 23 languages. So you might, of course, if it's your language, Germans always tell me, but Sven, how on earth can you say that's likely of confusion? This is totally descriptive. I said, yeah, because you are German, but there are 22 other languages which do not understand necessarily this German technical term. Yeah. So then, of course, our hands are tied and we need to rule for likelihood of confusion. In my view, there's a systemic mistake. Yeah? This is a huge problem. To be honest, I don't know how to solve it. I have a theory, if you allow me, I can tell you how to solve it, but it would be a total revolution of trademark law. Yeah, but as it stands now, the case law says you have to look at the country where there is likelihood of confusion. Yeah, of course, then if you find a country, you will always find a country, unless with English basic terms, that's different. But if you have Hungarian, for example, with all my due respect, many countries, nobody understands Hungarian. So of course, you will always have likelihood of confusion. Yeah. But in Hungary, they will say, okay, how can you do this? You get so much protection and now you can go after me. So there's a systemic mistake here in this system.
This is true, isn't it? The less you know about it, the more easily you are confused between different things.
Yeah, absolutely.
So if you have a trademark written in Japanese,
exactly,
looks like most other trademarks written in Japanese. It's just how long they are.
Exactly.
Or Arabic.
Yeah, and Chinese, Arabic. All these characters. Now the case law also have changed in the General Court. Now actually you have to consider not only the 23 languages, but also actually every other potential language. Yeah, so that makes it even more complex for us. And then, of course, you have always a big community of Japanese consumers, Chinese consumer, Arab consumer, Turkey consumer. You have them in the EU, and then actually it becomes very tricky.
Here's my next question. How long, for each of you, before you're pensioned off and been taken over by AI? Richard?
Well, I read a very interesting talk recently that was given at a conference for the Chancery judges in the part of the High Court where I operate by somebody who's a deputy judge who's doing a postgraduate degree in AI at Cambridge at the moment. And one of the very interesting things about it, this was about negligence. Can you be negligent if you use an AI tool that goes wrong, or you sell one that goes wrong? One of the things he said about it is it's all very well that they very, very often, 90% of the time, even more than judges, get the right answer, but you can never tell why. And that's the problem, actually. So, AI tools for medical diagnosis or whatever, they can be better than humans in many circumstances, but they're completely unauditable, because if they get the answer wrong, or indeed if they get the answer right, you don't know why. And since it's a crucial part of the judge's function to explain why, I think it'll be a long time before that can be replaced by an AI system.
I'm not
There was
convinced
another-
of
I'll give you
that.
another- I'll
If
give
people
you-
were accepted that how it worked.
Well, I'll give you another example, Robin. Yeah, I don't know if anybody's seen this in the general scientific press recently. A few years ago, AI started destroying the best players in the world at the game of Go, which I don't know very much about. And everybody said, oh, well, that's it. AI has cracked Go. We humans are redundant. And a couple of weeks ago, an amateur player, not a particularly strong player, smashed the AI to pieces because it didn't actually understand Go and it made some rudimentary mistakes. So I think it is premature to say that we will be falling victim to AI soon. So my answer is not for a long time, unless I suppose the general population decide that they are happy with a 85% correct AI result that they can't, whose reasoning they can't check.
Yeah, I once wrote an article about justice and what is justice against them talking Canada.
Yeah.
And I began with a very famous quote from the Lord Chief Justice: "Justice must not only be done, but must manifestly be seen to be done."
Yeah.
And I offered the opposition: it doesn't have to be done; it only manifestly must be seen to be done. And you can point to a point in history when that was true. Trial by ordeal. They thought that worked. So you could be replaced simply because people think that an AI machine is doing better.
Well, you've got the luxury of saying that from your position, Robin.
Do you think AI will have a significant effect in trademark examination? Or does it have it already?
They've done some research on the exam side on AI, which was quite interesting. And I think they used a cat. So they were trying to get the AI to recognise every formation of a cat. So they put in thousands of images, photorealistic images only, because that's the only thing it could recognise. And eventually they could get the machine to go, that's a cat, whatever the colour, whatever the angle. But then when you look at figurative trademarks, what it can't do is go, that's a cat on its hind legs with a cane and a top hat. I know that's a cat, because it doesn't. Because as soon as you change the configuration, it just can't work it out. So it ran into the ground in terms of figurative marks very quickly. And there were still people in IT who doggedly thought this could be done. And the more they tested it, the more it failed. Whether word marks are different, probably, but certainly with figurative marks. I know how long it takes examiners to compare figurative marks. And they've got eyes and can make all those assessments. But like you said, it might get lucky, but I don't think it would be making the right assessments. So I think it's a long way off. I'll be retired.
Well, that'll be all right.
Although I will say, I mean, in some jurisdictions, they're so swamped with cases that they have to use AI, at least to triage cases and to filter them down to something that can be put forward for human scrutiny. And Brazil's a very good example because they have just, not in our field, but in other aspects of their law, they've got so many cases that they need it to deal with the volume. So as long as you can have a human cross-check, this is for simple things, you know, at the stage of filing a claim to check dates and so on and so forth. But I mean, it is used in some systems. I think one thing actually that is terribly important is that people who talk about this in the context of the law, and let alone people who make decisions, inform themselves very clearly about what AI is and what it does and the different types of AI. I mean, I think a good example recently is what's been in the news about Google's search versus Microsoft search. A lot of people will say that's not really even AI, it's just a sort of language interpretation model. And so I think actually all of us who think about this have got an obligation to really get out there and inform ourselves what we're talking about.
I think my concern with it would be it could only work with factors and hard percentages. So if you're looking at a multifactorial assessment of how similar are the marks, how similar are the goods and services, how weak is the mark, how strong is the mark. You've got to let the AI machine have percentages of things to work that out on. And the one thing we always say is balance of probabilities, reasonableness, and we never pin down percentages. So how would that work? I don't know. I'm sceptical, I think, is what I'm saying. At the high end of making a multifactorial assessment that we make with many, many factors. So, yeah, I don't know.
No AI for a bit.
If you allow me, I think, I mean, can I?
Yes, please.
I mean, if you read books about artificial intelligence, they always come with two examples of the professions which will be the first one affected by AI. It's surgery, the medical sector in general, but in particular surgery and justice. I mean, the problem is I don't like it because there is a fundamental problem here with access to justice and how do you control this? This is true, but I mean, the train is already very fast. We will not stop it. So now the question is how we start to control it. For me, it's crystal clear. It's crystal clear that trademark law will be very soon done mostly by AI. I mean, come on, in 818 case, which is identity. I mean, you don't even need IA. It's so simple. But also the 81B cases. I mean, because the advantage of the trademark law is it's really relatively simple because you have these factors you have just said, and that's it. And then I always say that then you go to you use the shaker, and then you see what the likelihood of confusion. And let's be honest. I mean, with IR, we will be absolutely consistent 100%. I mean, how many cases you will find where we said that the low degree of similarity of goods, average degree of similarity of designs, weak distinctive, and then some say that there's likelihood of confusion. You will find a lot of other decisions where they say no likelihood of confusion. So this, of course, you will tackle with artificial intelligence. But I agree, there's still way to go. And of course, cases, for example, on bad faith or much more complex cases, infringement cases, that will take time. But I'm sure that will be taken over by AI. The only question is how we control it and where are the limits. But for the simple cases, I think we will have it relatively short.
Right, I don't know what time we're going to serve the drinks, but I think before we get to that, that the audience will put a few questions which have arisen from the questions, or they sort of new one. Anybody? I've got one last question. Who should win Sky Kick in the Supreme Court? Right, Sven? Who should win?
You ask me?
Yeah.
No, ask the audience.
All right. I'll ask the audience. Who should win Sky? Who should win Sky? Sky Kick. Yeah. Most of you have no views at all. Come on, tell that again. You must have a view. Sky. Who should win? Sky win? Sky Kick.
We're intervening, I can't say anything.
Okay.
Be careful.
You could intervene too. I mean, ask of interventions. Maybe you are intervening. I would.
I think they did it. I wasn't on the committee at the time.
Well, there was a sort of time before when there was a question of permission to appeal. And some professors intervened. I don't know whether you intervened. But I don't know whether the professors are intervening or whether you're intervening in the actual appeal. There's all sorts of rules about it.
If I may,
Yeah.
please don't forget, I mean, I'm looking out at you, Roland, I mean, we discussed it already, but maybe there are many other representatives of other user associations or even marks, because in our grant board cases, there is now the possibility that the user associations file observations or the amicus curiae. So please make use of it. It is extremely important for us to get all the views. I mean, we are sitting with 9 lawyers, we had 15 opinions, this is everywhere. But nevertheless, it's very interesting and to see the views of the user associations, right? And even because I heard from some user associations that they say, yeah, but our problem is we are so big and we will have we don't have one line to go, because there are also some say we need to go this way, we need to go to that way. That doesn't matter. Nobody tells you that you have to come to us and say, this is the line we as marks want to defend. No, you can even say, look, Grant Board. There are a lot of different lines, and these are the arguments. This is because we want, I think you said it, Richard, we want to take an informed decision. And in order to take an informed decision, we need to have all the input. Because otherwise, once we have taken the decision, we will be criticized by everybody. Rightly so. But please, if you want to criticize us, take the opportunity and bring forward your arguments and even the evidence.
It's like a general court, you have to support one side or the other. So you do actually have to come in.
Yeah, but not in ours. Yeah. This is, okay, that's different. That's a different system, yeah.
And the other, and repulse to that is, please condemn the courts and the general, the opposition boards. Could you kindly acknowledge our submissions? Because we've had a few where we put them in and it's been completely unmentioned. And it's sort of, oh, right. That's
You
a shame.
never even got a letter back saying they've received it.
And they got that far, but the decision didn't actually mention the amicus brief, which I thought was
But where was
a
it?
shame.
Where was it?
That was actually the general court.
Ah, okay, because of the grant, but we always mention
And it
it.
was one of the CJU,
Yeah.
and I think
Okay,
it would be nice if they were at least mentioned.
Yes, I mean, this is also important for you because you need, but we do it. It's our facts and arguments, and we will actually deal with. And actually, in one case, it was decisive because one user association actually put forward evidence to show that actually the opponent was right, that there was a shift in market reality. So it was very, very relevant arguments and evidence submitted by the user association.
Right, any more?
I was just going to come back on the geographical.
Yeah.
Oh, yes.
Sometimes you have a company like Hitachi, which then has such a big plant that they end up having a location. So when they register the trademark, they may not be a geographical location, but in due time they may become a geographical location. So do you now revoke the trademark because they gave their name also to a geographical location, and then other businesses could establish themselves there?
That's a very good question. Yeah, that's a very good question. And I remember there's a case, it's called Neuschwanstein, which is a castle in Germany. And the problem is I was the person many years ago who took the decision in the invalidity department. So the point was here, Neuschwanstein is not the name of the geographical area. It's completely different. It's the name of the castle. It wasn't invented, I think, by Ludwig, whoever. He gave this name. It's a fanciful name.
King Ludwig.
Yeah, exactly. It was an invented name. But what is true, and actually we went, the first instance, the Boards of Appeal, the General Court, and the Court of Justice, they all confirmed that Neuschwanstein is not a geographic name, and therefore it can be registered. However, in Germany, the case went totally the opposite way, and they are furious. Whenever I'm in Germany, they are furious. They always say, Sven, we need to talk about Neuschwanstein. No, I asked the moderator, can we change the... No, this is a good question, because they actually argue that in the consumer's perception nowadays, Neuschwanstein is actually not any longer only the castle, but it's also the name of the geographical area. But, and now comes the point, this was never argued and even less proved in our case. So had they proven by evidence, survey for example, that actually everybody relates Neuschwanstein not only to the castle but to the whole area, the case would have been different. But it was not argued, again, the quality of arguments is important, because that might have changed the whole issue, but it wasn't argued in our case. But I still believe that we took the right one, not the Germans.
Well, if it had become a geographical name, then the Germans would be right and you would be right, because nobody else get in front of you. So that's all right.
Exactly.
But there's a little message, yes, again. If you're going to prove something, prove it up to the hilt.
Oh, yes, please.
Don't mess about. Don't say, when the client says, is that enough? That's a bad rule. You say, there never can be enough. There was a very successful general for the Southern Party in the United States. Asked why he won so many battles. I get there the feuchtest with the moistest. Overwhelming. That's a little hint from me. And I think it's Drinky's time now. Thank you all very much, panel. You've been absolutely brilliant. You deserve it.